My name is Reeves Mahoney. I'm with the Mahoney Richmond firm. And we are a firm of 5 attorneys and 3 paralegals and 4 legal assistants that exclusively do family law. That's all that we do. Now, divorce is a recalibration of life. And if you're going to go through a recalibration of life, it's important that you be an educated consumer of legal services, especially when it comes to divorce. There's no question about it. And there's a whole lot of divorce attorneys out there, and there are a lot of very fine attorneys. But you have to be willing. It's sort of like going to a counselor or a doctor. If you go to a doctor and you get that off feeling, like I just don't want that guy operating on my torn ACL and meniscus, and you get a second opinion and then you feel more comfortable with that doctor and you go with that doctor. So the first thing that I recommend is that you interview at least 2 attorneys if you are seriously contemplating divorce. And you interview them with an idea of finding out what the scorecard is, what the issues are going to be in your divorce. Because I will tell you that you have people getting divorced in their 20s and their 30s and their 40s, 50s, 60s, 70s, 80s, 90s. And it's just 6 weeks ago, I got somebody who's 102 years old that wants to get divorced, okay? So it happened. No, God bless him. He's married to a 63-year-old and he says he can't keep up. But anyway, the important thing is that all of those people are at different stages of their lives. And so they have different needs and they have different considerations. If you are in your 20s and you've been married for 5 or 6 years and had no children and you're working, you're not going to be a real candidate for spousal support. If you've been married for 35 years and have raised 4 children and gave up your career opportunities, you're going to be a stellar candidate for spousal support. So it's really fact-driven by the individual facts of every divorce. And you have to ask questions of your attorney. And one of the handouts that I have brought today is what I call the 8 critical questions that you should be asking an attorney. And I say to you this, that if you're finding it awkward to ask questions of a potential attorney that you're considering that's going to take you through a divorce effort, then you shouldn't be retaining that attorney. Because if there's any awkwardness like that, and you're feeling that awkwardness of asking any of these questions, then that's an indication that there's some sort of problem there, and you definitely should interview a second. If not, and I've seen people interview 3 attorneys and swallow the financial insult of the cost of the initial consultation, and then really sleep on it and make an educated decision. You know, sometimes I facetiously refer to the infinite wisdom of our General Assembly up in Richmond, but this year I genuinely, with a full heart, refer to the infinite wisdom of the General Assembly, because finally I was a chair with the part of a committee that sought to pass a bill, and this plays off of what you were talking about. Spousal support. Now, if let's say you go all the way through a trial and you get to the end and the judge says, I give her X amount of dollars in spousal support per month. That means you're going to receive that, but it's going to stop if she dies, she remarries, or he dies. It's over. Now, one of the most alarming cases that I ever had in my life was 13 years ago. I represented a woman and she got a spousal support award. And it was $15,000 a month. And she did not go after the family business. Wasn't the largest business in the world because of that spousal support award. And I told her that I felt uncomfortable about that she should take less and get more money in equitable distribution up front. But she said, no, I really want that support package. That's the way I've budgeted it. And lo and behold, he drowned in Aruba swimming 2 years later. And so she came back and said, well, you know what happens? I said, you don't get the spousal support anymore. Now, at that time, if we had taken that case to trial, if I had asked a judge, there is an insurance policy in this marriage. So they decided that they were going to have a standard of living where they would protect themselves with an insurance policy. And I want you to allocate the death benefit. I would still go for half of the cash value, but I want you to allocate the death benefit to wife who's going to receive the spousal support until there's no longer a spousal support obligation. The court, if I had asked in that case 13 years ago, the court would have not had the jurisdiction to order that. Finally, 9 years ago, they made a provision where if you had a life insurance policy and you owed child support, you had to make the child the beneficiary of the death benefit. And so the court had the jurisdiction to do that. What I was working to do was to get a law passed that gave the court the jurisdiction to allocate a death benefit and basically ensure a spousal support income stream in the event of death of the payor. And so in that regard, the General Assembly this session, and it goes into effect on July 1 of this year, passed Section 20-107.1:1 of the Code of Virginia. Yes. And I'm really very excited about it because it's the first time that the court will have the jurisdiction. And let me say this, that they have a factors test. And one thing in divorce that I've got to tell you, if you look at spousal support, you look at equitable distribution, you look at custody, they always have these statutes with factors that the court is required to consider. They're really into factors. But the major factor that you have to emphasize if you're in the divorce process, and you will have insured, is that you've got to be testifying in front of the judge. We got that insurance policy in case he died. And it's normally you get the insurance policy on the alpha earner in the marriage. So if that alpha earner dies, you've got enough money to send the children to college and pay off the house, etc. That we got that insurance policy in the event of his death and that the children and I would be taken care of. And that allows the judge. That's really what the court is going to be looking for. So that is a huge development here in Virginia, which, as you know, if you look at a lot of Supreme Court cases, has not been the most, has not been a jurisdiction really at the vanguard, the cutting edge of the law. A lot of our stuff comes across from California, and we get it about 25 years later. That was like joint legal custody. Pardon? The person who's paying for the spousal support, the owner of the policy. He can be required to continue the policy. And that's one of the factors that if you've got a term policy, and let's say you're 64 years old and you got a 20-year level premium policy, and when you were 45 years old and it was going to run out when you were 65, and then the premium is going to skyrocket, that's one of the things that the court is going to look at as a factor as to whether they're going to order that the payor keep that insurance intact and have the death benefit allocable to the recipient of the spousal support. The next thing that is really important to emphasize, and what I really, where people such as Shari and Noel come in, is that they're providing things like long-term care. Now, one of the things that I am seeing more and more is, and it really, I mean, it's out there, it's incredible, especially if I'm seeing it. People are living longer, and they're having more vibrant lives. I think that the sort of retirement age of 65 has now sort of become a little bit of a joke, but you know, there are people that hit the lottery and retire at 50, and then they normally get bored and have a midlife crisis and they're working again. But anyway, the net is that you've got to plan when you are going through divorce. Never, ever reach a settlement, and never let a lawyer tell you, oh, you're so good looking and you're going to get married again, and there's going to be some knight in shining armor that's going to come swooping in, swing low, sweet chariot like the Archangel Gabriel, and just reach down and pull you out, you know, out of singlehood and put you in marital bliss again and just take care of you until the day you die. All right, well, you know, that's good for TV, but that's not good for real life. And so the problem is that one of the things that I do a lot in divorce, and of course, I'm getting people that are in that age range, and it's really important. I'm telling them from the very start, one of the things that I've noted in divorce is if you begin to make something an issue from the very start, it takes on a life of their own, and the other side begins to make concessions to that position that you've made. And I'll tell you, the case that really turned me on to that was literally, I mean, this is time traveling. 25 years ago, I represented this very nice lady, and she had received her husband's grandmother's ring as a ring that was given to her during the course of the marriage, and it was a family heirloom. And it happened to come from Tiffany's, and it was 2.95 carats, and it was this beautiful stone. I mean, it was a nice piece of ice, but everything. And so he wanted it back because it was a family heirloom, but she had really fallen in love with it, and as a matter of fact, and there was an issue of fact there, she had cared for the grandmother in her waning years. And so it meant a great deal that they had this relationship with each other. And I said, and I could tell that this ring was like really big. And so from the very first telephone call that I had with opposing counsel, it was, I'm just telling you right now, I said, we're going to trial in this case. 95% of all divorces settle. The other 5%, they just have to fight World War III. But I said, if we're going to settle this case, she has got to keep that ring. And every phone call, I said, don't forget about the ring. It got so that he would call up and he said, don't talk to me about the ring. And sure enough, when we came time, we had a judge, a retired judge that came in and we mediated that case. And the first thing I said, he wanted to know if anybody had any comments before we broke up into two different rooms, and he was going to do this shuttle diplomacy back and forth during the mediation to try to reach a comprehensive separation agreement, which is the holy grail in all of divorce. That allows you to stave off the prohibitive cost of trial, contested trial, because the farthest extreme that you're allowed to go in our society for legitimate conflict resolution is the courtroom. Unfortunately, the most expensive form of conflict resolution is full-blown trial through the courtroom. So you want to reach a separation agreement. And we're in there, and nobody wanted to say anything. In the opening, I said, I want to say something. I said, I have got to get this ring. I said, I don't care what happens in the rest of the assets, spouse support, I have got to get this ring. And so it was the ring, and sure enough, about 1:30 in the morning, everything had been agreed to but the ring. And I remember looking at opposing counsel and said, I told you 14 months ago about this ring, and you've never said one thing about the ring. In fact, you've told me to stop talking about the ring, and I can't stop talking about the ring, and I've got to have the ring. And this guy, he was there, I'll never forget it, and he said, just give her the blank, blank ring. And she got the ring. So what I'm saying is that what you've got to build into your budget, because you've got to look down the road. And here all of a sudden you were this marital unit, and you're going to be dividing into two different independent living units. And you've got to look down the road and what is going to take care of you. And you've got to start talking, if you are at that point in life, I need the money in my spousal support award to be able to pay the monthly premium for a long-term care insurance policy. And you go get a Shari Friedman or a Noel Evans, and you get them to come in and write a letter and say, this is what it would cost to start this person at this age, and here's an approximation of what the premium would be. And so then you've got an expert, it's not like, oh yeah, well she wants $1,000 a month, and you can get it for $200 a month. You've had a professional come in and talk and say, this is what is the approximate cost that it's going to be. And if you do that, and you continue to belabor that subject, you put it in your answers to interrogatories, you put it on your income and expense sheet that you use for the pendente lite hearing, which is right up front. After you file your complaint, that's the name of the initial pleading that you file with a court that starts your divorce. But you put it in there and you keep reinforcing, I need this money for this long-term care insurance policy. I'm telling you, it's got a way of materializing. So, having said that, I could probably speak for, like Noel, I could do a whole seminar on divorce, but I think I was given 10 minutes. But you know what? Andy Warhol gave me 15. And Marshall McLuhan said they're wearing us. So, if there aren't any questions, I'd gladly take questions. Thank you very much.